Okay. Are you all able to hear me okay? I got a message
Well,
that might.
I
Okay.
can hear you. Yeah.
Okay, perfect. So basically the purchaser agreed to pay back the supplier a borrowed amount of money in certain installments over a certain period of time. And if the payment was more than 10 days late, the whole amount that was borrowed is due immediately. So, first few months is fine. The payments are coming in, and except that they're coming in a little bit later than what was agreed on. So a few days late, a few days later. Um, but then the supplier didn't say anything. So then on the 19th payment, the supplier suddenly tells the purchaser, you've been late in your payments. You owe me the full amount now. And so then the lawyers argued back and forth, where they said, oh, but the supplier led the purchaser to believe that it was okay to pay them late. But the court said you cannot enforce that because it was a it was not a gratuitous promise. It was they led them to believe. They didn't say anything, but neither did they say that it was okay. So because they didn't actually have it in writing, there was no conversation. The supplier just sort of accepted the late payment, but didn't say anything like that. Uh, Equitable estoppel actually does not apply here. So the real life lesson learned is document everything with your client, with your subcontractor, with whatever it is, be it by email, be it by letter, report, meeting notes, whatever it is. Even if it's a phone conversation, you're going to type up an email afterwards saying, as per our discussion today, this, and this, because that would save you a lot of headache. Okay. All right. Next. So in contract law, there is something called a breach of contract. There are remedies and damages that might happen as a result of a breach of contract. So if a party in a contract fails to perform the obligations noted in the contract, then the party that failed to fulfill those obligations has essentially breached the contract. So for example, it could be, I will build this house for you by an X date. And if they don't meet that date timeline, then I have breached the contract. So the non-defaulting party is then entitled to damages or losses incurred as a result of that breach of contract. So, you have to spend extra money on a hotel, living somewhere else while you're waiting for me to finish building your house, let's say. So how is the amount of damages determined? Well, they have to be damages that are reasonably foreseeable at the time the contract was entered into. So for example, if I am late on building you a house, then you could say, well, the hotel bills I'm paying for is this much per day. And so if you're late by this much per day, this is how much you owe me for being late on building a house. So in the case of Cornwall Gravel Company and Perlator Co., what happened was that Perlator failed to deliver a tender document by the closing time. And if any of you have ever done a proposal and you needed to submit that by a certain deadline, they're very, very strict. Even if you're 10 seconds late on their clock, they'll say, nope, sorry, I cannot accept it. And you basically have done all that effort for nothing. So what happened was that Perlator was supposed to deliver this proposal on behalf of Cornwall Gravel Company to the client by a certain time. And in this case, they didn't. So Cornwall Gravel actually didn't end up getting the job because the owner wouldn't accept it. And so it turns out that they found out if Perlator had submitted it on time, they would have been the lowest bidder. They would have gotten the job. And so since a person in authority in Perlator knew about the consequences of failure, so I guess Cornwall Gravel Company had called up Perlator, a certain supervisor maybe, and said, hey, can you promise that you're going to get it in on this time if I gave you the package by this other time? And they said, yep, we're going to do that, no problem. So because there was that discussion, Per later understood how important it was to have this package delivered on time. Per later was actually forced to pay Cornwall $70,000 for the loss of profit of the job. Like, normally a per later package is maybe $30, $50 to deliver. They weren't able to just like give them the $30 or $50 back and say, oh, sorry, here's your refund for not being able to deliver your package on time. No, they had to pay Cornwall Gravel what the amount of profit or the contract would have been had it been delivered on time. So that's again, that whole idea of breach of contract. So be very, very careful. Real life lessons learned is always read the fine print. And a lot of times as engineers, we hate the legal language. It confuses the heck out of me. And so what you want to do is understand what are the clauses that you're signing on or that your company is signing to, because there are ramifications. So in the line of work that I have, especially being a team lead, I do need to read a lot of these legal agreements. I need to understand them. What is the liability that I'm signing off on when I do that for my company? And so there are some what we call indemnification clauses that if there was a breach of contract or whatever, we have to hold the client harmless and then defend them. And what that means, for those who may not understand, is that we actually have to hire our own lawyers to fight for the client against us. And that's just crazy, right? When you think about it. But these are the kind of clauses you need to read and understand so that if there was such a breach, this is what it means for the ramification and the damages. All right. So some of you may be asking, okay, how do we determine the actual amount of damages should be calculated? So there's different things that come into play. There is a duty to mitigate. So a party that suffers loss or is causing loss on some other person's part must take reasonable steps to mitigate and reduce that amount of damage if possible. So for example, if you left the tap running and it's spilling all over the floor, it's now getting to the next condo unit, well, turn off the tap. Don't leave it running, right? That seems easy to understand. If you lost a sub consultant, well, quickly go and find another one so that you can keep moving on the project. So it's that kind of idea of trying to mitigate the damage as much as you can. The next item to understand is exemption clauses. So that is where in the case that there is a breach, it's a term in the contract that is already agreed on, that it limits the liability of one party or both parties in what will happen when there is a fundamental breach, when there's a breach that is very large and it goes against the main contract. So for example, it could be that building a house by a certain date, and I missed the deadline for that date, and I'm being told, well, it's so many $100s per day for the hotel. And so I might have an exemption clause that says, I'll pay you that. However, it only goes up to $10,000, after which I pay you the $10,000 and I walk away. So that would be an exemption clause. And in the past, when there was a fundamental breach in the contract, the judge had ruled that no, you cannot hide behind the exemption clause because you did royally screw up. But nowadays, there was a reversal of that in the laws. And so the defendant can hide behind the exemption clause, as in the exemption clause does apply, because the judge had ruled, well, this clause was in the contract. You're both adults when you read the contract, you understood it, and you both signed and agreed to it. So yes, it is part of the contract. And even if there was a fundamental breach, you should be able to be protected by this exemption clause. So a case study to note is Hunter Engineering versus Syncrude, Canada. And there were defects discovered in the gearboxes, which would cause the repair cost to be $400,000. but the gears failed outside of the agreed warranty period. So be it the 1 year, 2 year, 10 year, whatever period that is. And so Syncrude actually sued the Hunter Engineering and said, well, the problem is a fundamental breach because the design of the gearbox was that it was inadequate. It was never going to work to begin with. So that's the root of the contract. It's not so much that's a faulty warranty thing. And so they went back and forth in trial. There was a clear and direct exemption clause. And so therefore, even though Hunter Engineering had to pay Syncrude for those damages and whatnot, but they were able to use the exemption clause and limit the amount of damage and the liability. All right, other things to consider is like penalty clauses or what we call liquidated damages. So you see that a lot in the construction industry when we are doing the contract administration for these construction projects for our clients. If they are late by a certain time frame, like then they can get charged by the client so many amount of dollars per calendar day, not work day, not Monday to Fridays, calendar day, for not having met that deadline. But it needs to be a pre-estimated reasonable amount. Like this is actually what the client is incurring as a cost for not having this product or this facility built by that certain time. There are also time limitations. So there's a limitation period in which the lawsuits and the courts can commence action on recovering these damages. Okay, so the next topic we do want to touch on quickly is business, employment, labor laws. We won't be able to get into everything, but there's a concept of restrictive covenant. And so what that is basically an agreement, a covenant, or a work contract that will limit the person on what they can do when they leave that job. So for example, an employer hires an employee and the work contract actually states that if the employee leaves, they're not allowed to open a similar company within 5 years of them leaving. So the issue and the concern here is that, well, if all the employers put that on their employees, there could be quite a bit of limitation on competition. It is then contrary to public interest, as we see a lot with the cell phone companies. You could only choose from a few large cell phone companies because they've eaten up all the little ones. And so there's less competition, right? Another issue would be restricting the employment opportunities of that individual once you leave. So essentially the employer is trying to handcuff you from leaving. And so these things are a problem. And you might ask, well, then is this restrictive covenant clause even enforceable? So it's yes and no. It depends. It'll be up to the employer to try to tell the judge why it should be enforceable, but it is enforceable if it is reasonable in circumstance. So the type of activity, the time frame in which it is going to restrict, and the geography. And it also needs to make sure that it does not adversely impact public interest, so that there still is enough competition to allow for the services to be obtained. So a possibly enforceable example would be, okay, if you leave this company, you cannot take away our trade secrets, and you also cannot talk to these clients that we have for the next month. Well, that's not too restrictive. So you just don't call them for a month, but you can pick up the phone and call them the next month, right? So that's not terrible. What would be really bad and likely not enforceable would be they go, you cannot do any engineering in all of North America for the next 10 years. Because that essentially means you have taken the person's ability to do their work and to have a livelihood for a very large period of time and half of the world. So that would definitely not be enforceable. Okay, so all of those topics were about contract law. Now we're going to talk about tort law, which essentially means negligence. So the definition of tort is a private or civil wrong or injury, and it involves someone doing something out of negligence. So not out of like malicious intent. They did not purposely choose to do this and go, well, I'm gonna like really make someone's life difficult and purposely do this against them. So it has to be like negligence. And it may arise either independently of a contract or no contract is even needed. They're just negligent on what they did. And so the fundamental purpose, and this is a very key item to remember if you're going to do the exam, is that the fundamental purpose of the tort law is to compensate the victim of the tort, of the negligence. It is not to punish the wrongdoer. So, because this is a civil sort of a court topic rather than a criminal topic. So criminal law would be out to try to punish the wrongdoer. The civil law side of things is really looking at how do you compensate the victims that have been impacted by this negligence. Now, that said, just because someone is found guilty of negligence in civil law does not mean they'll be found guilty of criminal negligence, and vice versa, because there are two different court systems with different purposes. So that's something for you to understand as well. And in order to succeed in a negligence case, the plaintiff, i.e. the victim, needs to prove these following elements. So they need to prove that there was a duty of care, that the defendant, the person who is being trialed as the wrongdoer, they need to show that they have been owed a duty of care by that person, and that there was a breach in that duty of care. They were supposed to have done this thing, they didn't do it, they were negligent, they missed something, forgot something, whatever it is. And that as a result of them breaching that duty of care, the victim's injuries or damages are a direct result of what happened. Okay, so let's put in a case study. Maybe that's going to help. So for Edgeworth Construction, which is the contractor, and then with ND Lee and Associates, which is the consultant, they got into a court case where the owner was BC Highway. So, but the contractor and the consultant have no contractual relationship with each other because they both are contracted to BC Highway, which is the owner. The contractor enters into that contract with the BC Highway to do the work. Based on the documents that were prepared by the consultant, the contractor puts in a bid price of $7 million. However, at the end of it all, when they finally finished constructing, it actually cost $20 million because of all the errors in the specifications and the drawings that were made by the consultant who was hired by the owner. And so the contractor said, well, you know, this is because the consultant was negligent in what they provided us. There was no way for us to guess that it was going to be $20 million when what they gave us made us calculate that it was only going to be $7 million. And they said that even though the documents were saying, oh, it's furnished only with general information for the bidders, it does not have any way warranty or guarantee that this is what it's going to be. The contractor still relied on that document. And so there is a duty of care to make sure that that document is as accurate and constructible and whatnot as it should be. And so the last bullet there, the purpose of supplying that information really was to allow the bidders to prepare a price as best as they can understand at the time. And the consultant knew that. And so they owed them a duty of care for that. And so as a result of the consultants either being sloppy or not including everything or whatever it is, the contractor wasn't able to actually foresee what the actual cost of this whole project should have been. And so they said they suffered a lot of financial hardship as a result. So the lesson learned here in real life is be careful when we do our engineering cost assessments. Be careful when we do the specification and the drawings, because oftentimes the owner and the contractor are relying on us to provide them with information to help them to understand what is it that they need to do, and that it is obviously buildable and complies with regulations and all that stuff. But also our clients oftentimes ask us, okay, can you give me a cost estimate? Because I need to go to council and get a certain amount of budget. So we can't just nilly-willy put a number on that and just like throw a number on the dartboard and go, oh, I'll be able like $10 million. You should actually go, depending on which stage of the design you're at, as you get further into your design, you should know a lot more about the details and get the cost estimates from the vendors and the equipment suppliers and the subcontractors and stuff like that to get a better idea as to what that cost would be. Okay, so why do we talk about negligence? Why is this important? So it's important to note, and this sort of bleeds into the ethics part, is that we as engineers, we're held to a higher standard, oftentimes much more at a higher level than other professions. And this is very clearly written in the Code of Ethics, which we will cover in the next session, that it is the duty of the practitioner, i.e. the engineer, to the public at all times. So not just when you're at your desk, at all times, to the fidelity of the public needs. We are also called to regard public welfare as paramount. So when the things that we do are relied on by the public for their safety and provision of, the comforts that we do have, be it driving across a bridge safely and so on, they are relying on our expert knowledge. And we have a duty of care to these people. Now, if we breach that duty of care, there could be drastic consequences as a result of our negligence. And so it's very important, not just for the exam, but also when we go into our workplaces, what is our duty of care? What is a standard, reasonable amount of care? What would the other engineers and other engineering firms, what would the regulations be expecting us to be doing in these cases? And ask yourself, did we meet that care? Right? So that famous saying, remember, with great power comes great responsibility. So as engineers, we do have a lot of that expert knowledge. That's the power that we have to do good for our community. But it comes with great responsibility. So be careful and don't just go through these exams just to pass it. But like when we do engineering work, we have to be held at a higher standard and live up to that standard. So let me give you a very sad example of when an engineer or a former engineer was negligent, and it ended up having severe consequences and even loss of life. So a few of you may have already heard about this incident. It is the Algo Center Mall incident in Elliott Lake. And it happened, just a few decades ago, or a decade ago. So the mall had structural problems to begin with. There were leaks all over the place, and it was left unrectified. And so what happened was the owner of the mall hired an engineer to see if this was structurally sound. And so this former engineer, Robert Wood, went for a site visit, wrote the report, and said, oh yeah, I think it's structurally sound. And that was 2 months before the building of the rooftop parking deck actually crashed into the mall. Even though way before all of this structural assessment and stuff like that was done, there were already complaints of concrete slabs falling on people. There were already leaks in the roof that was dripping on the patrons that were visiting the mall. Like there were obvious signs of structural integrity issues. But the former engineer wrote that report saying to the owner, oh no, seems good, that's fine, carry on. And so sadly, what happened was on June 23rd, 2012, a really large slab or portion of the parking deck actually crashed into the mall it killed 2 people, it injured 20 others. There were a lot of other damages as a result of, you know, the mall and whatnot. And it's just a really, really sad incident that could have been prevented if the engineer wasn't negligent, that he actually opened his eyes and saw all the issues that were actually there. So this is actually a reason why our Professional Engineers Ontario has implemented the Practice Evaluation and Knowledge Program, what we call the PEAK program, which is an annual requirement for professional engineers to do, where they are taking an ethics module, and they're also keeping up with their professional development so that they're keeping up to date on the regulations and the rules. They are tracking to make sure that based on their role in the company or their service to the public, how many hours of these training they need to do to keep up to speed. Oh, and just a reminder, the first part is coming up due very, very soon at the end of January. So you haven't done the ethics module and you haven't done the survey yet, please make sure you do that. All right, so there's a few other important concepts for the law of professional practice. These are just some definitions. You'll have to go and do the other definition, look up yourself. But for example, vicarious liability is a very easy thing that they're going to test you on. So what that means is essentially the employer or the company is held liable for the employee's wrongdoing. The liability of the employee themselves is vicariously transferred over to the company that oversees the person's work. So how that works is, if for me, I am an engineer, but I work under RV Anderson. So I myself don't have insurance for my practice because I practice engineering through RV Anderson to provide engineering services to the public. I myself am not sort of giving out my own business card to the public and saying, hey, I can solve your engineering problems. Come hire me directly. If you are an entrepreneur, if you are an engineer who is offering public services directly to the public, you need to get your own certificate of authorization. You cannot, and that would require you to get your own insurance as well. You cannot be offering direct engineering service to a public if you don't have these things, because it is obviously a big risk. So this is very different than, let's say, a doctor, because a doctor needs to get their own insurance. Whereas for the most part, if you're an engineer and you're working for a company, they have that umbrella insurance that covers you in case there is negligence or issues that come up. So that's what it means by vicarious liability. God forbid, but if something does happen and I am liable, whatever, my company covers me in that whole court legal proceedings and whatnot. The next thing is concurrent tortfeasors. So if there are 2 or more quote, quote, wrongdoers, they may not yet be convicted of being a wrongdoer, but if they're being named by the plaintiff as being the people that are held responsible for such a negligence act, these are what we call concurrent tortfeasors. And until they get to the final legal decision, they may be both on trial until they figure out, okay, who's actually liable to this plaintiff and how much of a responsibility do each of these concurrent tortfeasors have. It could be 10% for one guy, 90% for the other. It could be 50-50. It could be 0 for one, and he's no longer found to be negligent or liable, and the other one holds all the responsibility. So it really is up to the court, but there could be at any time more than one wrongdoer in the court case. Another term to consider is disclaimer and qualifying statements. So what that is basically a statement that sort of limits or states what the conditions are for the use of certain content. So for example, this presentation is meant to help you with studying the NPPE. However, you do have to do your own studying. You do have to read the syllabus. You have to read the textbook in order to pass. So attending this session, as much as I do appreciate your time, does not guarantee you a pass. You have to do your own studying. That itself is a disclaimer or a qualifying statement. So I see that it is just shortly after noon. So these are the other definitions that I'm not going to have time to go through, but please do take a look through those and find the definitions for them in the syllabus and in the textbooks because they can show up on your NPPE questions. So with that, I'll open the floor up to questions on the law part, and then we'll take a short bio break, and then we can move on to the ethics.
Okay, so that's good. So if you have any question, if you can use the hand raise option, that will be greatly appreciated. Yes, go ahead, Javed and Amsa.
Just one quick thing. The engineering company who prepares the documents, the package, and releases for bid, are they required to make a cost estimate of the project and it is shared with the client, or the range is shared with the contractors too?
Good, very good question. I cannot speak on all industries, but definitely within my industry, we are expected and asked by the client to prepare a cost estimate, or what we call a opinion of probable cost, to the client. Now, it is up to the client if they wish to share that range with the contractors, but usually they don't, because they want to know what the contractor is actually going to give them. They want to know the like cheapest price, right? So if the client goes and says, oh yeah, my engineer says it's going to be 10 million, then all the contractors are going to like sneak in just underneath 10 million. Versus a contractor might say, oh, I could actually do it for 7, and someone might say 11, right?
So there's a classification of contractors here in the industry, like 10 million, 20 million, 50 million, something like that. Mm-hmm. There is a classification.
So there are different contractors that are, depending on the size of their company, mm-hmm. They might go, oh, that project's too big for us. We won't be able to do something like that. And so the client can say like, oh, this is in the range of like a very high level, like it's 100 million or it's below 100 million. And then the contractor can quickly go, yeah, no.
I see. Yeah. One of the place I noticed that you said a subcontractor is paid by the client. I'm trying to understand. Generally, the subcontractor works under the main or the general contractor. Yes. So the payment should go from the contractor to the subcontractor. But one of the places I noticed you said a subcontract is paid by the client directly.
Oh, sorry. If that was the case, I do apologize. That should.
Oh, okay.
Yeah. Okay. Thank you for paying attention, though. I appreciate it.
Thank you.
Yeah, Fakir, go ahead.
Are you on mute?
Fakir, you are on mute.
Hello?
Yes, can you hear me now?
Yes.
I can hear you.
Yeah. Thank you very much. Okay, so actually I was listening to one of your example that you, in which you said that the BC highway was the main contractor, and there was a consultant and a contractor also. Mm-hmm. So the contractor got the wrong specification from the consultant, and because of that, they realized that they have quoted a wrong number for the project. So what was the proceedings then when the case is submitted to the court? So how did they find that the consultant was the mistake of the consultant, and how it was ended up? So that thing I think was not covered when you were giving this example. So can you elaborate a little bit on it?
So essentially, from my understanding, and you can always go and read the case a little bit more detailed, what happened was the consultant was hired by the owner, which is the BC Highway, to prepare the design package with the specifications and the drawings to specify what needed to be done by the contractor. But because of not being fully doing the due diligence of the engineering work, they may have left out quite a few things that the contractor found, well, they weren't able to actually build the highway or do whatever it is that they needed to for the 7 million. It ended up that the cost ballooned much more to 20 million because of all the errors from the consultant. So I don't think that it necessarily cost the contractor $20 million, but it's that the bid price would have been a lot more had the package of the design been more well done. At the end of the day, the contractor will still get paid for what they do.
Okay, so who was held responsible? I mean, the consultant was fined.
The consultant.
The consultant.
Yeah.
Okay, and who originally it was the responsibility to overview the work of the consultant? It was the client, or it was the contractor? Because you are saying that the contractor is ultimately going to get the amount, whatever they are going to spend on the project. So that means it was the responsibility of the client, because the client has hired the consultant. And if the consultant has not done something correct, so this was primarily the responsibility of the client. And it would be in between the client and the consultant if the case goes to the court. So the contractor would not be the party of that the case. Am I right? If this understanding is correct?
Sort of, partially. So the owner is not an engineer. They don't have the expertise to overlook an engineering document and say whether or not it's complete or good enough to meet regulations. That's why they hire the consultant. So the consultant in this case is found negligent for what they've done and provided to the owner. And so if anything, the owner would probably go back to the consultant and say, well, hey, I suddenly had to incur this $20 million bill because of your own negligence. So you need to pay me as well.
Yeah, my question was that the case would be in between the client and the consultant. Obviously, as you said, that the owner is not the engineering expert. So the parties in that case would be the owner and the consultant, and the consultant under the duty of care, they will be held liable for whatever the losses occur. Is it right?
But in this case, the contractor actually went after the consultant first. I'm sure the owner also went after the consultant too. Whenever they can, they'll just go and pull everybody in.
But there was no relation between the consultant and the contractor. There was no contractual relation between the consultant and the contractor. Actually, the owner hired the consultant. Owner hired the contractor. So there was a relation between the contractor and the owner. There was a relation between the contractor and the consultant. No relation between consultant and the contractor. So the law proceedings should go through the way where the contract exists. So if the two parties are not linked, they cannot bring them in court.
So not exactly. So it's not a contract law case. It is a negligence tort case. So I think I understand where you're coming from, where there was no contract between the contractor and the consultant. So why even sue them, right?
Yeah.
And that is valid. It is not a breach of a contract between the contractor and the consultant. That's not what we're talking about. What we're talking about here is that because the consultant was negligent, other people suffer damages as a result of the negligent act. So it's a separate topic. Okay,
so that means the suffering party has to initiate the case, and then everybody will come into loop.
Yeah. Basically, in a negligence, there is no need for a contract. There just needs to be proof that there was a duty of care. The consultant had owed the client as well as the contractor a duty of care to provide the documents in a way that would allow them to build what needed to be built, that it needs to meet regulations and all of that stuff. If they didn't do that and they breached that duty of care, anyone can go after them.
Thank you. Thank you very much, Roika.
Yeah. Well, thank you for clarifying your question.
No problem.
Okay, the next one is Faizan, you. Go ahead.
Thank you, Rika, for the presentation. One quick question. So I think you mentioned about the tort law and the criminal law. So a plaintiff can take the cases like at both the court at the same time,
Yes,
so that he can just get the money from the tort and then
from both. Yep. From
okay,
both.
so that both can be done at the same time, or okay.
Or one and then the other. Yes. The ruling could be different. They could find them civilly negligent and then not criminally negligent, or they could find them both civilly negligent and criminally negligent. Yeah.
Okay. Yeah. Thank you.
Okay, next one is Abbas. Go ahead.
Yeah, same continuation of the negligence. What if in the case of the consultant party, maybe the consultant had hired some member of the consultant team, and that member who had done that consultation had left the company. And so in that case, what will happen? Will the consultant company be held liable, or they just move on because the person who was acting on behalf of the consultant company had left the company?
Very good question. That does make it complicated, and it does happen very often, right? People really don't stay in a company for their whole life anymore. So as a result, the courts see the company as a person. I know it's a very odd concept, but essentially when a lawsuit happens, they go and they, let's say, sue R.V. Anderson. They see R.V. Anderson as the person. RICA law doesn't mean anything. I just happen to be part of R.V. Anderson. So they go after R.V. Anderson. They don't go after me personally. In a criminal, they can try to come after me personally. But the company is still, as we said, vicarious liability transfers to me. Even when I leave, they might pull me back to be a witness. They may pull me back to stand and provide my input and stuff like that on what I did or didn't do. But the person being sued is R.V. Anderson.
No, I think it's a very good response. But what I meant to say that, okay, the person who was the guy representing the consultant company, and he had left also. But in that case, okay, if the liability is on the consultant company, but the consultant company who had allowed that particular person to go away had nothing to do with, I mean, they did not have any clause with the person who had left, that, okay, you can be recalled for any kind of negligence thing and all that. So in that case, and when that person leaves the company, it's a big company, for example, the consult company, and it's not necessary that they may be they could have overlooked that particular assignment which was given to that particular person. And then when they get involved in the negligence case, will it not be very hard for the company to respond or
Absolutely.
come back?
Yes.
So it will be a sort of something of their repute being challenged, or
It definitely does. It does make it very complicated for the people who are still in the company that needs to go fight the court case when the person is no longer there.
Still the thing will be on the company itself, the consultant company.
The lawsuit will most likely be against the company. They will be the ones pulling the lawyers. They can ask the person to come back and stand trial. Like the court is always able to pull the person into trial.
Okay.
The disciplinary measures would be coming through PEO to that person directly if they're found negligent, though.
Okay.
So the lawsuit would be against the company because they have the deeper pockets, right? Again, the whole concurrent tortfeasors is we're trying to compensate the victim.
Okay.
So who has the deeper pockets? Unfortunately, it's the company, unless you're, Bill Gates or whatever. So that's why they go after the company. But in terms of, and we'll talk about the disciplinary measures thereafter, but the PO, if it's found that, that person was really the cause for the negligent act, they may have disciplinary measures against that particular license holder.
Correct. Okay. Got it. Thanks.
Yeah.
Thanks.
Good
Thanks
question.
for the clarification.
Yep.
Yeah. Anyone else has any question? I don't see any hand raised, Rika. So
Okay, perfect. So do you want a 5-minute break before we move on to the next topic? I do realize it's 12:17.
So how about we come back at 12:25? Is that okay?
Sounds good. Yep.
Okay, so let's come back at 12:25 to resume the other part of this workshop, which is the ethics. Okay. So
Okay, lovely.
let's
See you all then.
go
Yeah,
for it.
that's good. That's good. Yeah, thanks.
So 12:25, we'll come back.
Okay,
Thanks.
thank you.
Hello.
Okay, 12:25 is everyone is back. I cannot hear anyone.
Miss Munira, I'm here.
I am back.
Okay. If you all can show your hand gestures that you are here back, that will be appreciated. Either raise your hand or to put it in a chat. Good, thanks, Javed. Thanks, Faizan. Thanks, Noor. Okay, thanks, Anas. Shazia, you're back?
Yeah.
Yes, yes, Munir, I'm back. I'm here.
Okay, I think most of us
I'm
are
back.
back, right? Okay, thanks.
Yes,
Thanks, everyone. Okay,
yes,
yeah. So
no
Rika,
problem.
over
You
to
can
you.
continue.
Okay, perfect. Thanks for joining back so on time. I'm very impressed. Okay, so the previous discussion was all about the law, contract law, negligence. Now we're talking about ethics. There are still some components of law related to that, but the idea is to focus on why we do what we do and the standard that we're held to. So in professionalism, there's the topic of professionalism, one of the 6 areas you need to know. There will be definitions and interpretations of those particular topics. The items that we're going to talk about are the ones in red, which is the role and responsibility of professionals in the society, as well as the engineering and geoscience profession in Canada, and how that then relates to what we do or the safeguarding of public. So in terms of the roles and responsibilities of professionals in society, the engineering profession is a skilled and regulated practice. What that means is that not everybody can just call themselves an engineer, or they should not be. They can say that they're doing engineering work, but they cannot say that they are an engineer. And so because it is a profession, there is personal accountability and responsibility of the way the person conducts their work in that professional practice. They are held accountable to that professional practice by their employer, by the regulations, by the supervisor. And there is definitely a dependence on the confidence of the stakeholders, be it the employers, the clients, the authorities, and the public, to trust that what we do is good, that is for the safeguarding of the people and of property. And so as a result, we therefore need to uphold that trust that they give us, right? And so the key idea is that as engineers, we are to protect the public. And what we mean by public is the general public at large. We also mean the client that we work for, the employer that we work under, and the employees themselves. So their colleagues, the people that work under you, whatnot. The word protect means not just a physical protection in terms of safety and avoiding damaging property or material, but it means also environmental protection. Making decisions that are understanding of what the implications are to the environment. So personally, for me, with my line of work, when I do water, wastewater treatment, that does come into play quite a lot. And then there's also a requirement to protect economically. And you're like, what the heck does that mean? So it means that when you come up with solutions and alternatives to the client, you are understanding that there are implications in an economical point of view of what those decisions and alternatives mean. So you would be telling the client, okay, if you choose this alternative, it's going to cost you this much in construction, but it'll also cost you this much to keep the equipment going for the next, 50 years that it's going to be working for you. And it is understanding that when we make decisions, we do need to consider the economical impact that it has on society and the client and so on. In addition, for the engineering and geo professionals in Canada, what they're going to test you on is the role of the PEO. What do they do and not do for you? In Ontario, we are under the PEO. If you're from a different province or territory, it would be under their jurisdiction and they may have something different. But for the most part, the provincial and territory associations will help you, and they manage the licensing and the self-regulation of the professions, which also means that they will discipline and enforce any of the rules and regulations that they have come up with. They have jurisdiction and independence between associations. So sometimes that means that if, let's say, I move from Ontario to Alberta, I do have the ability to transfer my license over to an Alberta license fairly easily. I, for the most part, do not need to go through all the same rigmarole as someone who comes new or just got their bachelor and trying to get their way into an engineering license. The PEO is also there to establish the standards that the professionals are going to be held to, including like what is practical for practice and code of ethics, how you're going to use the stamp and so on and so on. What they don't do for you is they will not hire a lawyer when you're in trouble. So again, is that idea of the company that you work for would have that insurance to cover you. Or if you yourself are practicing engineering services for the public directly, you would have to get your own insurance and your own lawyers if you're in trouble. They also do not advertise for you or your business. So you might see at the back of the bus, those ads for personal liability lawyers, or even like certain other professions, accountants and whatnot. You will never see that with an engineer. We are held to very strict terms as to what we can advertise and whatnot. So the PEO also will not be advertising for you and your business. They also do not set salary standards. So the doctors and the nurses, their regulatory body may help them with those things. But for us, we are fairly much free to do what is required to set our own salary standards by the company and by the services that we provide. And the associations also do not hold proceedings on criminal attempts. They will hold proceedings on professional misconduct, but again, it's that whole professional misconduct, negligence kind of a realm of civil court rather than, it's not even a court really, it's a disciplinary hearing versus like criminal court. They don't get into that territory. So another thing that's very important once you do get your professional license is you are given that rubber stamp. The stamp is what is important. And so we have to be very careful how we use that stamp. The PEO gives a bunch of guidelines as to what you should do and should not do, where you can stamp and where you should not stamp. They also say you should be not obscuring the stamp. You need to sign and date. So a stamp alone doesn't mean anything. The practitioner needs to have signed and dated that stamp. in order for it to hold the power. So if someone steals your stamp, if your 2-year-old decides to take your stamp and just like stamp it all over the place, don't worry. It doesn't mean that you are in trouble, but you should definitely safely shred that piece of paper. So until you sign and date it, it doesn't hold the same weight. Different practitioners can stamp the same drawings. So for example, in my work, I might have a drawing that has both process as well as electrical items on that same drawing. And so I cannot stamp for anything that I'm not competent in. And we'll have a talk about that in the next few slides. So in which case I will stamp for process, and someone like Fasan or Mohammed would have to stamp for the electrical. And we would literally under our stamp would say for process, and then they would say for electrical. And it is important to be clear as to what it is that you're responsible for, what you're stamping for. So the next line there is about stamping only the final product. If it's a preliminary, if it's a draft, if it is not the final product that actually goes to construction or is used by the client as a final report, those other sub stages, those are the documents that you don't sign and stamp. You only do the final ones. Also be very careful if you're being asked to seal as-built drawings. We do not seal as-built drawings. We can seal record drawings, which means that the practitioner has gone out to verify for themselves that everything that the contractor has told you is constructed at this elevation, at this distance or whatever, that you verified it yourself, and that therefore you can stamp it. Otherwise, you should not be stamping those as-built drawings, because you're basically putting your professional seal on something that someone else has done if you have not verified it. All right. So the other thing to consider is that even though you don't seal it, if you yourself wrote the report, you may still be found responsible and liable because you prepared it or because your role was to review it as a QA reviewer or whatever. So again, that whole higher standard of care, right? That whatever it is that you're doing, be it sealed or not, you are held to that duty of care. So just something to keep in mind. And then that link at the bottom is a webinar that tells you a bit more about the do's and the don'ts of the seal and whatnot. All right, so getting into some of the more interesting ethics parts of things. So the top 2 items will leave you to go and study. I've heard that with the NPPE questions, sometimes they sneak in an ethical theory and whatnot. So you might want to read up on that. But really, at the end of the day, the key crux of it is the level of standard we're held to, which is by the Code of Ethics, and then want to talk about some of the ethical issues that do come up on a possible basis throughout the career. So what is ethics? Well, ethics is the study of right and wrong, good and evil. We must be ethical in our practice as professional engineers, and the argument of what is ethical and what is not could be held in a psychology course or a philosophy course, but as engineers, it is very clean cut. They gave it to you in the regulations. So section 72 is the definition of what is a professional misconduct. They list out all these different things. If you did this, that's deemed as professional misconduct. You would have possible disciplinary measures held against you and so on. And section 77 is the Code of Ethics. This is that standard that we're being held to. So here is the links if you want to go and explore it. But I've basically summarized it for you here in these next few slides. So 77I or 1 is really about the general duty of an action with respect to how we conduct ourselves in the society. 77.2 is the duty that we have in regard to the practitioner, the goals and the ideals that we should be holding ourselves to. 77.3 is about our duty to the employers. 77.4 is our duty in relationship to the clients. 77.5 is be it with a concurrent employer and clients. So we'll talk about moonlighting. 77.6 is how we relate to other professionals, not necessarily engineers, but other professional licensed associations and the people that practice them. 77.7 is how we relate to other engineers as practitioners, and 77.8 is about the profession itself. So let's dive into some of what that means. So 77.1 in general says it is the duty of the practitioner to the public, to the practitioner's employer, and to the practitioner's clients, to members of that practitioner's profession, and so on, to act at all times, and we did say it already, fairness and loyalty to the clients and associates and whatnot, fidelity to public needs. So we definitely highlighted that in the negligence discussion. Devotion to high ideals of personal honor and professional integrity. We do need to keep up with our knowledge base, so hence why the PEAK program that's been implemented. And we are to practice within our area of competence. So we'll be talking about that in following slides. So in terms of our duty in relationship with the employer, so here's a scenario. So let's say that I just changed my job and my new employer wants me to disclose confidential information from my previous job, like give them all the trade secrets because that's why they hired me. So because of the code of ethics, we need to maintain the current and even previous employer confidential information. So we should not be disclosing that, even though that might be what our current employer wants us to do. So a practitioner shall act in a professional manner towards the current as well as past employers, being faithful with the information that we have gotten, particularly if it's confidential information. And so in the way we conduct ourselves so that we don't end up disclosing and getting ourselves into conflicts of interest. So talking about conflict of interest, what exactly is that? So that's when you have a perceived, it may not even be an actual conflict of interest, but it's perceived from someone else that you are biased towards a certain party or decision because of your own vested interest in it. And so if you have such a conflict of interest, the person should promptly, voluntarily, and completely disclose that conflict to the relevant parties. This then allows all the parties to make an informed decision as to how to manage the situation. So the problem itself is not that there is a conflict of interest. That does happen. The problem is when it is hidden and not told to anyone, and then there are subsequent consequences that result. And sometimes even when you disclose the conflict of interest to the various parties, they may go, well, thank you for being honest. I really do appreciate it. But I still think you would be able to make an unbiased decision about this. And so we would like you to continue to be part of that panel, making decisions or whatever it is. It is then still up to you if you still feel that it might be a conflict of interest for yourself. And so you want to back yourself away from that, and you can still decline and say you would really like to avoid that situation, and you voluntarily pull yourself out. So that could happen as well. So here's an example of a conflict of interest. So company X is thinking of merging with company Y, and engineer Z is on the board of directors and gets to be part of the decision-making process if the merger is going to go through. So after some evaluation, the board of directors, including engineer Z, takes a vote and they decide to merge with company Y. So that all sounds fine and dandy, right? It makes sense. However, later that night, engineer Z takes out the VP of company Y for dinner and says, "Congratulations, honey, I think we've made the right decision." So, wah wah. Seems like there is a lot more than just the company relations going on here between the board of directors on company X and the VP of company Y. So that would be a conflict of interest. So what needs to be done? Well, if you can, please avoid it. Don't get yourself into that situation. Although you cannot always avoid it. So even in like the previous situation there, engineer Z isn't going to go, "Oh, I'm going to step down from the board of directors," or "I'm going to divorce my wife." Like, that doesn't make sense. But in the case that a conflict of interest has happened, you could refuse to be on the decision-making process of the merger. In which case, then there is no conflict of interest. You pulled yourself out. You can also, if you cannot refuse, you can also disclose, or you should be disclosing to the relevant parties, to your board of directors, to the company Y as well, that, hey, I am married to the VP of company Y. And so if you fully, promptly, voluntarily disclose all of that, then the decision makers are able to make an informed decision, and they can say, "Yep, thank you for letting us know. We do agree you should not be on the board for making a decision on the merger. Please continue to stay on the board of directors to govern the company on other aspects, but for the votes, we won't be counting your vote," right? So that's the way to deal with conflict of interest. So a real life lesson is that in 2016, a former Halton region manager was actually found guilty of accepting bribes, in essence, getting luxury cars, renos, really nice vacations, because he was in a position to choose which companies were going to get awarded for infrastructure projects. And in return of being of choosing certain companies, those companies would give him these things, or say they'll give him these things if he gets to choose them. So that is a conflict of interest because of the role that he has in Halton region at that time. And this was a big uproar. It made it on the news. And this is a reason why a lot of the municipalities these days are like, "Thank you for your invite to dinner or lunch. I either won't be attending or I'm going to be paying for my own lunch. Thanks. I want to avoid the conflict of interest." This example would also be a secret commission, kind of an example in an ethics situation. So again, we are held to a high standard. We should not be allowing these secret commissions and bribes or these conflict of interest not be disclosed. Okay, so in terms of our duty to the clients, there is a case study I want to share with you and explore with you. So there was a landowner or developer that paid an engineer to carry out planning of a study on how to develop a piece of land. So they want to go and service it with, let's say, municipal water, wastewater services. So the engineer goes and does the work, they write the report, and they get paid by the developer. Then the municipality that has the jurisdiction over that developer's land then wants to retain the same engineer who prepared the report for that developer, not so much because they worked with that developer, but because the engineer's expertise was well known for that type of work, and they would like to have that person review what was submitted by that developer. So the engineer is reviewing like their own work. So what should the engineer do? So the engineer must recognize that there is a potential conflict of interest, right? How do you review your own work and still be advised by it? So number one would be disclose that conflict of interest to the municipality. The municipality might deem it to be okay in that they will still want to hire the engineer to review the other subdivision applications, but maybe just choose a different engineer specifically for the assignment related to this developer to avoid the conflict of interest. Or the alternative is that the municipality goes, okay, thank you for letting me know, but really I don't foresee it being a problem. Unlikely, but anyways, it could happen. So this does not resolve the engineer's potential conflict though. They actually need to go a step further. So again, we're held to a high standard of care. The engineer needs to advise the municipality that, you know, the assignment will be accepted only if the developer also agrees that there is no conflict of interest. And once there is a written agreement obtained, then the assignment with the municipality can be accepted. And if no written consent from the other party is provided, then the municipality can still generally hire the engineer, but just not for that specific case. And in which case that closes any of the doors for potential conflict of interest. Both of the parties, the municipality as well as the landowner, the developer, acknowledge that, you know, they either see a concern or they don't see a concern, and they have it in writing. All right. Next item is around the relationship that we might have with concurrent employers and or clients. So this is what we call moonlighting. When a practitioner is working for company X, but they also take on a job as an engineer or otherwise, doesn't have to be an engineer. You could be, you know, doing, I don't know, dog walking for another company. And so where the job for one will actually impact the other. So for example, let's say I work as an engineer for RV Anderson during the day, but at nighttime, the government actually pays me to fight crime because I have superhero powers. I don't, but let's just say that's an example. So that's moonlighting, because I am actually being paid and hired by RV Anderson, but I'm also paid and hired by the government. But because of my work continuously at nighttime fighting crime, I am very tired during the day. I don't finish my work as an engineer during the day, and it ends up impacting my practice. So the solution to moonlighting, and moonlighting in itself is not the ethical problem. People do get multiple jobs. It is okay. Where it is a problem is that if you don't let the two parties know and help them understand what are the implications of me getting a different job, like a second job. So the solution really to this issue is to provide the different parties involved, the two different companies or the company and the client, written statement as to what is the nature of the jobs that I have and the resulting limitations in order to be faithful to my employer or to that client. And the work that I do as a superhero is not to conflict with my engineering duties or to code of ethics. And I do need to inform the various people. So that is in regarding to the ethical approach to having multiple jobs, one of which is engineering. If you're not an engineer, then we won't hold you to that standard. But if you are an engineer and then you're also taking on a different job, then yes, we are still going to hold you to that standard. Next item is about the duty to other practitioners. So we work with different colleagues, we work with different engineers, and basically it's stating that a practitioner shall not attempt to gain an advantage over other practitioners by paying or accepting commission in securing professional engineering work. So that's the whole idea of secret commission. So for example, engineer A and company X agreed to work for client Y, but that for additional profit that the client makes as a result of the engineer's work, he gets a cut of the profit without telling company X. So it's like money under the table just for you. So that's a problem, definitely an ethical problem. The engineer must never accept secret commission. Don't accept that nice BMW or the Benz when acting as an agent to the client and the employer, because it is a conflict of interest. It may result in criminal charges, as we've seen that it actually happened. It is disgraceful and dishonest to the professional engineering industry. It really is. And it is unfaithful and unfair to not just the employer, it could be to the public, it could be to other practitioners. All right, so, you know, there are conflicts between technical authority and management authority sometimes, and you're like, what do I do? So it could be that my client ignores my advice. What should I do? And I have had that happen before. And so what you want to do as an engineer, you're not always going to be able to convince them about everything. And at the end of the day, they do get to choose to do what they want to do with their money. You need to explain your advice in a way that is clear, that is written down, so that it's difficult to contest if they take you to court. And it needs to explain the consequences of what it means when they ignore your advice. So for example, not that this has happened, but if I say that, oh, if you don't give this treatment system enough time to do what it needs to disinfect the bacteria, you cannot discharge it. And they go, Rika, I don't have that kind of time. I don't have that kind of space. We're just going to discharge. So we would be saying to them, no, you cannot, right? You could kill people as a result of this. So it needs to be in writing. It needs to be clear, and it would give them a chance to understand what the advice is and the consequences of them to ignore it. Now, if they continue to ignore it and there are indeed negative implications to the public welfare, your job doesn't stop there. You do need to report it to the required regulatory agencies. So be it with PEO registrar. For me, it would be with the MECP, which is the Ministry of Environment. And sorry about that. The registrar can help step in to support the engineer as a spokesperson, as someone to go between the different actions and the players. Give me a second. Okay. So the next item is, let's say the employer actually instructs me to do something that I know is wrong. So this is the whole whistleblowing concept. And even if the instructor or the supervisor says to you to do something and it's illegal, you need to refuse to do it because it is your license that is on the line. Sometimes your supervisor or owner is not an engineer. They're just a business person. So they're like, well, this saves me money, so I'm telling you to do this. But if it is going to harm the public, become a problem, you need to refuse. Because at the end of the day, public welfare is the top priority for engineers. Okay? But at the same time, to be faithful to the supervisor and the owner, again, you need to clearly explain the reason and the consequences of that. They may not know that, oh, them saving money and telling you to use less chemicals for the disinfection of the treatment plant is going to kill people. They may not understand that, but once you explain it to them, they may come to realize, oh, that is a problem. So no, never mind. I changed my mind. Thank you for not getting us into legal issues. Please continue with putting in the chemicals that you need to. Okay. So yeah, we talked about, that's essentially the concept of whistleblowing. Sorry, I'm just gonna do a cough stop. Okay. So whistleblowing is essentially the definition of revealing a wrongdoing or misconduct, but without authorization. Like the people have not given you the okay to blow and to voice that concern. And so a case study would be, you find yourself in a situation where the colleague or employer is doing something illegal or unethical. You have a responsibility to report, because it becomes a conflict of interest. It could be something that could really harm the public. But at the same time, if you blow the whistle on them, they probably are not going to like you. They may fire you, they may sue you, there may be expenses that you incur as a result of hiring your own lawyers or loss of job or whatever it is. So what should you do? Well, the engineer should diplomatically notify the situation to the person. So go to the person first, talk it out with them. They may not understand that what they're doing is legal. They may not understand that what they're doing is wrong or puts public safety at risk. And if they actually listen to you and they take your advice, then you know what? That's good. You don't need to do anything further. They will remedy it. They're going to take into action what you suggest and so on. If, however, they are not willing to listen, they continue to not listen, then you do need to go to the PEO, you need to go to the regulating bodies. And a very special note here, as much as a lot of people are now doing this, do not go to social media as the first step. Don't go ranting and raving that, you know, they really should have done this, they didn't listen to me and all that stuff, because that in itself is, again, a problem with you not being faithful to your employer, your client, or whatnot, giving away trade secrets. So that in itself, if you go to social media, is going to be a problem on your end, even though they are also wrong. The first step is, again, talk to the person. And then if they don't listen, talk to the PO or the regulating bodies that could help back you up. So I want to share a video with you that helps you understand there is protection for the whistleblower, at least as engineers, because our profession holds us to such a high standard. There is protection for those who need to do the right thing, but could end up getting in trouble as a result of doing the right thing. So give me a second while I switch over to the screen. All right. And so this is a short 2-minute video, and it talks about the protection that is available if you do end up getting into this situation of having to do a whistleblowing. And let me know if you can hear the audio.
You're an engineer working in the petroleum manufacturing sector, and you're proud of the work you've done and the standards you maintain. On site, you've discovered an emissions level that is way over ministry maximums. You know that this has the potential to harm both people and the local environment. And it's clear to you that your colleagues, some of whom are very close friends, are not following public reporting protocols. You know that if you raise this issue to management, your job is on the line. What if you could act on your conscience and report this further, knowing that you'd be insured and protected no matter what the outcome? Fact is, you can. In many Canadian provinces and territories, if you are a licensed engineer or geoscientist, you are protected by a secondary professional liability program. It covers you in situations where reporting inappropriate or illegal activity or design occurs. This whistleblower coverage in your insurance specifically protects you for legal advice and for loss of income. There's even an 800 number you can call to get advice and understand the specifics of your coverage. So if you have uncovered unethical or dangerous practices and you want to act on it and make it right, or even if you aren't 100% sure and want legal advice, your coverage through the secondary professional liability policy will help you. It's good to know you've got a safety net when acting to the highest standard of professionalism, and meeting your ethical responsibility as an engineer or geoscientist means you may be putting your career at risk. Your secondary professional liability coverage allows you to act with confidence. Take a closer look here.
Okay, so hopefully that does give you some confidence that even though we're holding the engineers to a higher standard, there are associations that help us to maintain that higher standard. Let me just switch back to my PowerPoint. Okay, can you see the slide again?
Yes.
Okay, perfect, thank you. All right, almost to the end. So the next topic we want to talk about is about competence. We as professional engineers should only practice in the area of our competence, because we are held to a high standard. They're trusting our expertise in this area to do what we need to do to understand the regulations and so on. And because the public safety and welfare is dependent on us doing that, we should not be doing anything that we don't have experience in. So an example would be, you are interviewing for a well-paying job, but it requires you to lead a project in an area that you had only minor experience in. So you might have seen someone else do it, but you yourself don't know how to do it. And there'll be a team under you who will rely on your expertise and your direction. And you just got the call that you're the chosen candidate. So you must have done really well in the interview, but you actually don't know your stuff. What should you do? Right? So in analyzing the situation, the key issue here is that you're going to lead the project. You're going to lead a team, and they're all going to rely on your expertise. But you cannot lead someone, you cannot lead them well, if you yourself don't have that experience. So to choose to accept the work would end up being professional misconduct. You would end up being unfaithful to your employer, the staff, the team, the client, and possibly end up hurting the public. So therefore, to uphold the ethical duties and to avoid disciplinary sanctions and whatnot, you really should not accept that job. Which is a crushing blow, right? But at the same time, if let's say the job was an entry-level job into that project, and you can learn under someone who knows what they're doing, that's how you can build up the experience and end up becoming competent afterwards. But it really depends on like, where are you in that role? So some people might ask, okay, well, can someone with a bachelor's degree in civil engineering end up doing mechanical engineering work? The answer is, well, it depends. If the person also learned under a mechanical engineer how to undertake this mechanical engineering work, then yeah, they could, because the bachelor degree or the academic degree that you got does not dictate, nor does it limit the engineering profession and the knowledge and the services that you could end up acquiring and learning about in your career. But you do need to only work within the area of expertise that you have. Now, if the person says, oh yeah, I can do the mechanical engineer's work, I've watched a few YouTube videos and I've taken a few courses, that should make me qualified. In that case, no, it doesn't. So I've taken a snippet of what an engineer license looks like. It essentially says that you are a professional engineer under the province of Ontario, It doesn't say, so-and-so is a process engineer or a mechanical engineer or electrical engineer, it doesn't limit you like that. They do it on purpose because they understand that people could end up branching and learning different sectors of engineering throughout their career, and they don't want to limit them on that. But it just, again, is then up to us to make sure we practice within our area of competence. So a bonus slide, because you could get tested on this, is in regard to disciplinary procedures. So like we said before, the PEO, as one of their responsibilities, is to implement disciplinary measures for the practitioners that do not end up meeting and upholding the professional responsibilities that we have as engineers. So under the Act, the association, again, their priority is to protect the public. And so they may do so by responding to complaints that happen as a result of a practitioner doing unprofessional activities or whatnot. And so when someone submits a complaint to the PEO, then stage 1 happens, where the PEO gets an investigator to help the complainant to fill out the required forms. The document then gets sent to the engineer that is being questioned and investigated, and the engineer does get a chance to provide a response. That's stage 1. At this point in stage 1, the original complaint person, their identity is kept confidential. Okay, so if people are afraid of being known and having, I don't know, action taken against them as a result of filing a complaint, the PO protects that person that way by keeping their identity confidential. Step number 2 then is that there is a formal consideration where the review package by the person who made the complaint and also the response from the engineer gets reviewed by a complaints committee in the PEO. And then they go and they make a decision on the outcome. So does it need a formal hearing from the disciplinary committee? Like, is it actually severe and they do see that there's an issue? If yes, it moves on to the next stage. Maybe right on the spot, they'll say, okay, I understand what the issue is. Here's a penalty. This is what's going to happen. They could go to then a different direction. They could go, well, I heard the complaint, but really the response from the engineer has clarified everything. We're going to dismiss this case. Or it could be sort of like a gray area. They're going, well, there's not sufficient evidence, so we're going to go back to stage 1 and investigate further, get more evidence. So again, at stage 2, the complainant identity is still confidential. Now, in stage 3, that's prosecution by the PO. This is where the panel from the disciplinary committee will be selected to hear the matter, and they are going to review the case. And so then a formal hearing with stage 4 happens, where the discipline committee then takes on the case. The engineer gets pulled to that hearing. The complainant's identity does get made known, but in this stage, the complainant is no longer involved in any of the hearings or the case. It is directly between the PO, because that's the jurisdiction that they have as the professional association, and the engineer. So it isn't any more of the person who made the complaint that is involved. Really, the action is between the PO and the engineer, and the consequences could be revoking or suspending the license. It could be limiting the amount or the type of work they're allowed to work in if there was an area of incompetence, working outside of their area of competence. They could end up fining the engineer, or they can force them to rewrite the NPPE if they want to continue to practice. Okay, so hopefully that was a good quick summary as to some of the key topics that would be encountered on the NPPE. These are the references and the textbooks that have been recommended by the PEO for you to use. Please do be careful of which edition that you get, because they have had several iterations throughout the years, but we have noted which are the editions to use. And so with that, I'll open the floor to questions on ethics.
Okay, so same way, if you have any question, please raise your hand. Yeah, Faizan, go ahead, unmute.
Erika, yeah, this topic is more like relevant. So for example, give you a scenario. If I'm working on a project dealing with a certain like a generator supplier, and probably he just visit me, and then after that, like give me some swags or like a Timmy card. So what is the fine line? Like, can I accept it? Do I need to surrender it to my HR? Because this happens.
It does happen. And it is a very hard gray line. It's a very soft gray line, sorry. So it depends on the company policy, because you want to lean on what is it that the company has told you is okay to do and not okay to do. That might be able to tell you. I don't think RV Anderson has that explicit policy on a Tim's card, but if it was something like much larger, then yes, you would need to tell your boss, and then they would be able to make a ruling on whether or not it ends up being added to I don't know, a raffle draw that we have, so that it's not just going to you, it's going to whoever ends up being the winner of the raffle, just to help with the conflict of interest, right? There are some municipalities who have taken that approach where they say, thank you, I really appreciate the gesture, but I won't be able to accept. So again, it goes back to what the company policy is. And for you yourself, if you don't feel comfortable taking it, then you don't take it. If anything, you could err on the side of caution. But if it's just a Tim's card and it's not going to make a difference in your judgment, then, you know, that is your judgment call. PEO is not going to pull you to disciplinary measures for a $10 Tim card.
Thanks.
Okay, anyone else?
If no one else, then I have another question. Like, I think in the earlier slide, you mentioned that we need to hold the ethics in like at all the times. For example, if I'm at the job, I send out to do a condition assessment for anything. I just run into a wastewater treatment plant and then find out like area classification issues. So I need to tell to the client right away or come back and then evaluate and then send it out. Or out of the job, let's say if I walk into any restaurant or any other thing and find out, oh, the wiring is not up to the code or it's facing some issues, and then it can hurt public. So I just go and talk to the owner right away. So how this thing is applicable?
Very, very good question. So yeah, you caught on to a very good key phrase where it said, we are to safeguard public at all times. So not just when we're at our desk, and you're very right, when you go on site visits, even if it's not specifically to your job there, but you see someone walking along the top of the roof and they're not tied off. It may not even be electrical related, right? It could be that that person did not do the safety equipment that they should be. And they're walking along the roof, at any time they could fall and end up either hurting themselves or dying. So if it's in those kind of areas, the site safety is always to the contractor. It's their responsibility. You would be alerting the contractor. I'm saying to the supervisor, hey, that person's not tied off. I'm letting you know. I'm transferring that responsibility to you to make sure that they do tie off. Now, to your whole like restaurant incident, yes, you would tell the supervisor of that restaurant, and you could say, you know, be careful. I see that this is an incident. This is what it could mean. So don't take it lightly, kind of thing. So yes, you would need to alert and report it. Now you could also make it a business case where you go, my company is able to help you out. We can give you assistance on this, but you can also choose other engineers, firms to help you with this as well. So that's being faithful to your employer as well, because you're saying, hey, there's a job opportunity here. This is what we can help you. And at the same time, you're giving the person not just a problem, but a solution. We are here to help. We can help you out. If you're going on site and you see a different area of classification and yeah, they did not do it properly because at that time, the regulations did not require that to happen. We've had those kind of projects before, haven't we? Then yeah, we do need to take it back to our team and understand the situation a bit better. And then go back to the client and say, hey, when I was on site, I noticed that this area was not classified and all that stuff. We're letting you know that it is a problem. These are the risks. But the client at the end of the day, they may still choose not to do anything, or they may say, thank you for letting us know. We also have it on our list of things to do. But at the moment, this is like down here on our list. But you can't force them to bump it up to the top, right? Like all you could do is like really tell them like, okay, but this is dangerous. And again, you need to weigh your risks, right? If it's class 1 zone 2, then maybe it's not as likely to happen. But if it's a class 1 zone 1 and they did not classify it at all, it's like, oh, that's a big problem.
Yeah.
Yeah. So yeah, hopefully that helped to answer your question.
Yeah, thanks.
Okay. Next one is Abbas.
Yeah. Okay. Yeah. Just telling that some on your observation on something which is not okay according to code of ethics, or if you see anything which is not according to the requirement of regulation requirement and all that, just does that only mentioning to the to your employer or owner verbally fulfills the condition that you have observed it and then informed the owner verbally, but for fear of your job or the conditions or backlash from the employer, you don't put it in writing, or you just verbally mention to him and that's it. So does it fulfill your obligation being the complainer that okay, this thing which happened is not according to the code of ethics, or is not or is in conflict with the regulations?
Yeah, so great question. It's always good to talk to them first, verbally, because I think you could get a lot more understanding or opportunity for understanding when you do that in person and communicate it verbally. But at the end of the day, if something does happen and nothing is written down, you have nothing to stand on. Because it'll end up being, I did tell you. No, you didn't. How do you prove that, right? Whereas if you do end up writing something down after you talk to them, then at least if the lawyers do come your way, or the disciplinary measure, a disciplinary committee comes your way, you go, I did tell them, and this is the email documentation I have. Now, I do understand it is scary, absolutely, to have to tell your boss what you're doing was wrong. And that's where you may want to talk to them at first, feel them out. Are they accepting of the message that you're telling them? And it's definitely a lot better when you tell them, oh, I noticed this problem, but we can solve it this way. And that would help reduce the risk for the company or litigation, lawsuits, whatever public concerns if we did this. Like, you're presenting it as a whole package rather than just saying, oh, it's a problem. You are a problem. So you want to present it as a whole problem and solution. Now, if they're very adamant that they're not going to listen to you and you're concerned about your ability to keep your job and all that stuff, that's where the PEO is there to help you, right? And again, even Engineers Canada, that website that I was showing you, there are agencies available to help you keep your code of ethics, to help you walk that very hard, difficult road when it seems like everyone's against you and no one is on your side. Because they do realize that what you're doing when you whistleblow is difficult and you could have personal consequences as a result. So they are there to help you. You can call up the PEO and you could say, hey, I have this situation. I've already talked to my boss. How can I best put it in writing? And they can help you with that. Does that help?
Yeah, okay. I understand that. Because I think always something to be given written is for your own sake, and you may not at least you will not feel the pinch of the problem which may occur later on. Yeah, okay, thanks.
That's right.
Thanks.
And oftentimes the issue doesn't come up right away. Like the big problem doesn't show up right away. It could take several years for it to actually come to a big problem. So by that time, you're like, I think I talked to this person, but it's been 5 years. I don't really remember all the details. That's where the lawyers will come at you and go, but how do you even remember that you did that? Are you sure you said that? So when you have something written down, even if your own notes, you may not even submit it just yet. You're like writing it down and you're talking to PO about how best to present it to that person. Something written is still better than nothing written.
Next one is Fakir.
Yes, thank you, Abid. Okay, so Rita, my question is related to the conflict of interest. So you mentioned at the very beginning that presented an example of a manager in Halton region who accepted the price, and you described it as a conflict of interest. So this is a bit confusing for me. I would consider it as a misuse of powers. And the conflict of interest, as I understand, is something if you are related to somebody and that entity is a part of the process, and you also are a part of the process, then it basically defines the conflict of interest. So how do you say that the misuse of the powers, even though I don't know if I'm a manager, I'm involved in the wrong kind of the practices, I don't know the suppliers and the contractors. I have no relations with them. They come to my table and they offer me some kind of advice, and and if I'm the bad guy, I accept that right, right. So it's how do you say that it's a conflict of interest? It is, for me, it is just a bad practice or misuse of power. So would you please elaborate? Where is the gap in my understanding?
Yep. Okay. That's a good question. So in the case of that former Halton region manager, one of his roles is to consider and evaluate who the winning bidders are. And so because of that, or he gets to direct the team to say, oh, go pick that guy. So because either he himself directly gets to choose or he gets to direct someone to choose, and he has chosen to favor the companies that actually did give him something, that is that conflict of interest. If he pulled himself out of the evaluation process and he does not tell the team one way or the other who to choose, then that would not necessarily be a conflict of interest. But because his role allows him that responsibility and power, and he, even if it's perceived to have biased these companies, that becomes a conflict of interest.
I'm not very much clear. You are saying, because I'm the manager, I have the authority to evaluate the offers, right? and because I have some kind of under table deals with some particular participants, so I'm giving them the favor, though I don't know that person earlier. So this is, I would consider it is a bad practice, is a misuse of power. So conflict of interest is not something that you're already know somebody and you and that person is the part of the process. Then it should be called a conflict of interest.
So conflict.
It's something interesting because I always heard that the conflict of interest is somewhere. Because for example, because I belong to the real estate, so I'll give you an example of the real estate. If I'm a real estate agent, if I'm selling my own house, then I have to declare it. This house belongs to me, and I'm also the agent of this transaction. Right? So because this is something belongs to me, that is why I'm declaring it. If I don't declare it, then it will be considered the conflict of interest. So if I don't know the entities in the process and because of some kind of the price I'm offering, they're giving them the preference. So would it not be just called the bad practice?
So the lawyers are very intelligent to use many different.
It would come under the criminal act, right? Because if you are doing something wrong by taking the money, so this is something kind of the criminal activity, right? So it will be executed under the criminal code of law, right? So it would not be considered the conflict of interest. That is my point.
So the definition for conflict of interest is if there's a perceived bias.
Perceived bias, that is the point. Perceived bias. So perceived bias, you mean that even in the bribe is the kind of the perceived bias?
Don't know that person who is giving you the bribe.
I don't know that person, but he just came to me and he offered me, and I'm agreed to give the favor. So it was not, the other people cannot perceive it. They cannot perceive it because I have no relation with that person.
But as in, if someone else hears about it, they could perceive it as a conflict of interest.
No.
They could perceive it as that your decision is not a neutral one because of
just because of the relationship. It could only be perceived in the sense that if I have some kind of the relationship, if I declare as per ethics, it's okay. Everybody would be okay. If I don't declare and it comes to the knowledge to the other people afterwards, then it will be considered as it will be perceived as because of the interest I gave them the favor. So that is my point. The conflict of interest. The example that you quoted, I feel that this is not a very good example to quote as a conflict of interest.
Okay, that's fine. Thank you for sharing your opinion.
Yeah, thank you.
Okay, next one is Shazia.
Thank you, Munir. First of all, I would like to say thanks, Rika and Munir. Excellent presentation. I would love to learn more about from you, Rika. Thank you. And my question is, just I need your assistance, your advice. I was working with contractor. Now I'm working from client side. My close friend who is working with the same contractor in the same organization. And nowadays I'm in the middle of the contract award process. And my close friend knows me very well and asking about the confidential document, and I refused him very politely. So this is count under ethics aspect. So could you please advise me accordingly? What should I do in this matter?
Okay. So remind me again, they asked, but you refused, right?
Yes, but very politely because my good friend.
That's okay. That's okay. You're allowed to be polite and still refuse. That's fine. I think that's the best way to refuse, right? With a smile.
Yeah, with the smile because but I did not give any confidential information because I think it's ethics. I'm not allowed to provide the confidential information for even my family or whatever. But he knows me very well. He knows each and everything about me. Yeah.
Yep. And so I think the fact that you refused is good. Now, it is up to you if you want to and if you're going to continue to be able to refuse anybody that asks, then that's good. Now, if you're starting to feel uncomfortable and you want to tell your manager, I just want to let you know that in my current role with this particular project, there is this particular contractor or vendor that I do know. And you let the boss know, do you still want me to evaluate this particular project and this package, or do you prefer to have someone else step in, but I still continue my role with the other projects and evaluations?
Okay, so do I need to bring it this knowledge into my manager, my boss, right?
Mm-hmm. Yeah.
Okay.
So that they could make the ruling. Yeah.
Oh, okay.
Yeah.
Oh,
they shouldn't be firing you from your job or anything like that. If anything,
Yes.
they should appreciate you for your honesty, because otherwise it could be a perceived problem.
Yes. Yes, nowadays I'm in very critical condition. So thank you so much. Thanks for your kind advice, because I was thinking, do I need to bring it up in my boss knowledge or not, because we are the same pool, same resource pool. So that's why I'm just thinking like that.
Yeah, and let the boss know you have already refused.
Okay.
Yeah.
But I'm just considering he will trust on me or no, like if I share with him.
I certainly hope the boss will trust you, but again, it's up to them if they're able to. They might see a bigger picture, right? They may know more about what your role in this is, and they may still keep you in the overall role, but just for this particular decision making, they may ask you to step aside from that, and then once they choose who that successful bidder is, you might be able to join back in. Like it's going to be up to them to decide.
Okay. Thank you so much. Thanks for your kind advice. Thanks.
Okay. Anyone else has any question? Just counting 1, 2, 3. So no one has any questions. So I would like to say thank to you, Rika, for spending time with us on the busy weekend, because I know, and in fact, the whole team, all the members too, to give time on the weekend, because weekend is busy for most of us. We have to do all kinds of household work, grocery and all that. And in spite of that, we spend some time on that. And Rika, I just want to acknowledge you and recognize you for your effort. Appreciate all this presentation and excellent presentation and all the good example case study. So just want to recognize you. Thanks a lot for spending time. And anyone from the member side, if you guys like the presentation and this workshop, you can just share your something in the chat or any hand gesture. If you like, if you can applaud it. And I will hand over to the Vice President of yeah, go ahead.
Sorry, Munir, can I add one thing if you don't mind?
Sure.
I think this presentation was excellent and an excellent message to all of us as far as the knowledge is concerned. And I think Rika has done justice to her name, Rika Law. So you are the law for all this kind of presentation, and I really appreciate what you have contributed today to our Nedians. Thank you.
Thanks, Abbas. I appreciate it.
Yeah,
so yeah,
thank you.
as I mentioned to you, Rika, thanks a lot. So I just wanna hand over to the Vice President of our alumni, NED alumni, Mr. Javed Nadeem, for any closing remark. But before that, Rika, you wanna say something? Go ahead.
Oh, just as a plug for the next session.
Yeah.
So my colleague Frank Fang, so he will be, whenever that date is decided on, he will actually be bringing a discussion on the logistics and how the marking is going to go, and then also discuss with you some example questions that might come up from such exams to help prepare you for the practical aspects of studying. So hopefully you'll be able to join then as well. I think it will be a really good session. I work with Frank, and I've seen the sessions that he's done at RVA, and I really like them as well. So thank you all for your time. It's been great. I really appreciate all the questions and the statements and just the sharing that you have had as well. It's been a very engaging session, and I'm very happy to have spent my Saturday with you.
Okay, so for this next session, I will communicate to the members when we are planning to have that. So this is more related to the exams questions and answers, right?
Yes.
Okay. Thanks. So now over to you, Sir Javed Inam sir.
Thanks, Munir. Let me correct my name. My name is Javed Inam. You just mentioned the second name different from my actual name. Anyway,
okay,
I first thank all the attendees, the participants for being so patient for about a couple of 2.5 hours rather. And some very good, intelligent questions were asked. So the session was very informative, and overall it was really very helpful. And thanks to Rika, she did it for more than 2.5 hours without losing the energy. She was answering the questions so confidently and so pleasantly that I'm really impressed. So the session was not only useful for the new engineers who are getting ready to write the professional engineering exam. In fact, it is useful to the people who may think of opening a business of engineering and construction. So we know the law now, and anybody who is interested. So Moni, thank you for arranging such a useful and informative session. And thanks to you, thanks to your team. I would request all the participants to just let the other engineers know, let the other Canadians know that we are, this one was a part of our continued effort to enhance and provide the knowledge, may gear them up and develop their to the challenges of the local market. That is good for the newcomers as well as for the people who wanted to switch to the profession. So that's been very nice, and I would really request all of you to go to your friends, colleagues, and your area of acquaintances to let them know that we are here to help the people, the Canadians. And in fact, 3 committees are working very hard. One which is professional development, which Munir is chairing. Then Shazia, the one participant who asked the question in the end, she is chairing the mentoring committee. And then there is another guy by the name Javed Hanif, who is chairing the training committee. So we have like all these things, all these committees, and we ourselves are ready to help whosoever requires help. So help us propagate this thing, and help us help others to know that we exist and we are there to help them out. In the end, Rika Asen asked you a good question. I was just saying that your name fits into your profession. So you changed the name lately, or it was like this before?
This is my father's last name. So
you guys are lawyers from the beginning.
So my cousin is a lawyer.
Well
so
said, Javisa, well said.
I get to be whatever I want now because we already fulfilled the lawyer requirement. Our cousin is the sacrificial lamb. I could be an engineer. Great. My sister's a pharmacist, and
great. Yeah. Rika, you did a good job today for all of us, and for the new people, for the people who are willing to switch over, and even for the people who are thinking to open up an engineering or a construction company. So thank you. Thanks to everybody. Thank all of you. And Munir, hand over to you all.
Yeah, one last thing I would say that I will appreciate if all those people who have attended, if you guys kindly provide a feedback through through email to our alumni, that how you like this session, any positive, negative, anything that will be appreciated.
Be honest. I have a thick skin, so anything that you give me constructive criticism will help me to improve for the future.
and also positive. So anything good, you like it, and what can we do? Okay, so that's all. Thanks, Rika. Appreciate all your time, and thanks all the member. Okay,
Thank you.
Thank
have
you
a
so
good
much.
weekend, all of
Yep.
you.
Thank you.
Enjoy. Stay safe.
Thank
Thank
you.
you so much. Thanks,
Thank you. Thank
everyone.
you.
Thank you. Bye.
Thank you so much.
Thank you so much. Thank you all.
Thank
Have
you.
a nice weekend. Bye-bye.
Thank you guys. Nice weekend for everybody. Thank you.